Hello and good morning. Happy Saturday, everybody. My name is Meghan Maes, and this is Being Civil in Minnesota. This is a place to come every Saturday at 10, where I go live and I talk about issues impacting families in the state of Minnesota, as well as kind of what the rules are for court. I am a lawyer, but this is not intended to be legal advice. This does not make me your lawyer. So, but this is a great place to come, ask questions, get some free resources. I got some great questions this week, so we'll be talking about a few member questions. If you do want to ask questions to the group, you can join us on Facebook at Being Civil in Minnesota, and you can ask a question anonymously, and I will come on Saturdays and answer your questions. Or I will answer them right on the Facebook group. So if you know somebody who's going through a family law issue or has questions about the court, please refer them to this resource. So I got a great question today from a friend of mine about tracking your kids. And this is becoming a bigger topic with the increase in technology and the misuse sort of technology for harassment or stalking purposes. Obviously, a lot of technology is made with the greatest intent. That doesn't always mean it's being used correctly. So the question this morning was, can you talk about tracking kids? They saw an article about a woman who had sewn a camera into her daughter's jacket and was spying on her at daycare. Can you do this for the purpose of just knowing where your kid is, even if they will be with the other parent at times? So, that's a really good question. And in the state of Minnesota, there is a statute that talks about when and how you can use electronic communications for monitoring purposes. And that statute is 626A.35. I give you those just for reference. And so that talks about that it is in the state of Minnesota, you are not allowed to use a mobile tracking device without first getting a court order. The exception to that rule is you can use a mobile tracking device if you are the owner of the object, or the owner of the object has given you their consent for you to track them. Now that gets into a whole slew of questions about whether or not can you consent on behalf of your child. So there's, hey, good morning. So there's lots of interesting case law around the jurisdictions regarding audio recordings of children. And in some jurisdictions, it's okay for a parent to consent to have their child be recorded. In other states, they say that is not possible. But just thinking about, the idea of a tracking device kind of sounds, very spy-ish, right? But how many parents out there have kids with cell phones? A lot of times, location tracking information is going to be shared. There's Life 360 now, or other similar kinds of apps that you can use to locate your kiddo, make sure that they're safe. So a lot of times, and as the owner of the phone, the question is, are you able to go ahead and put that kind of tracking device or tracking mechanism on the phone? The question I would have is, what is the purpose, right? So let's say you have an elderly parent, right, and you want to get them like a life alert to put around their neck. Well, are they really able to consent to that? Depends on their mental capacity, kind of like a child, an adult. Sometimes they can have incapacity sort of ability to consent. And I'll talk about that a little bit more with the power of attorney. The issue is going to be, what are what are you going to use this for, and what is going to happen if the other parent finds out and you have not disclosed it to them? So there was a story about somebody who put up like a nanny cam in their home, right? And if you are one of the individuals on the nanny cam being recorded, Minnesota's a one-party consent state, meaning if you are one of the parties to that conversation between two people, you can consent to that being recorded. Well, what if you are not part of that conversation? You're not supposed to be recording other people without their consent. Now, the statute that I referenced talks about you can't do it without a court order. And I think there are certain circumstances where a judge may be open to an idea, or the idea that a location identifying device or a recording kind of device may be appropriate in your certain situation. I could think of examples where maybe one of the parents has taken the child before and not returned them, so location identifying information may be important. I've had cases where FaceTime conversations are recorded because there's concerns about information or inappropriate topics or conversations being brought up during those conversations, and it's just sort of to protect the parties from false accusations. Really, it's going to come down to what does the judge find is reasonable. And, if you say, well, I put this tracking device in this diaper bag, and I own the diaper bag, and I'm letting the other parent use the diaper bag, so I can technically put that tracking device in there. You still may have to go in front of a judge and explain why you thought that was necessary or appropriate, because the other parent may find it an invasion of their privacy, or there could be a possibility that they might want to get a court order that says you can't do that, or a harassment restraining order. And you can get those if somebody does repeated unwanted actions that interfere with your safety, stability, or security. I could see some judges saying that, yeah, if you're tracking the location of another individual, adult, without their permission, knowledge, consent, that's how people are using these kind of devices for stalking and inappropriate purposes. So you want to make sure that, and you may get the other person's permission, right? So like if you have kiddos with special needs, or if you have kiddos that are, runners, or there may be some medical reasons as to why you would want to have that kind of in-time information. Completely legitimate. So yes, answer is incredibly complicated. If you have more questions about that, please post them in the chat or comment on the video. The other question I got was whether or not you can get a power of attorney for your aging parents after divorce. Well, so first of all, what is a power of attorney? A power of attorney is a document that gives somebody permission to sort of take over the, sort of financial kind of decisions for another individual. In order to do that, the parent would need to be able to consent, meaning they have to have capacity. They have to be competent to say, yes, I want you to take care of my my day-to-day stuff. If they are able to consent and they do have the capacity, then you would fill out the form. You can find those online at the Minnesota Judicial Branch website, or you can find them on lawhelpmn.org. It's a form that you would fill out, and it talks about what types of responsibilities that you would have as the attorney in fact. The fact that the parents are divorced, I don't think is factually relevant as long as the adult that is wanting to have a power of attorney consents to it, then their marital status isn't going to prevent them from granting that responsibility to their attorney, in fact. So I am on location today at my in-laws, so I'm going to make this video short so I can go finish my coffee upstairs and catch up. I hope you guys have a great rest of your Saturday. Keep the questions coming, and please refer people to this resource if you think it will be helpful. Take care.